Thank
Let
you.
me defer to Senator Johnson.
Thank you, Mr. Chairman. I'll start by saying this is probably a lose-lose proposition for me even asking these questions, but I do think somebody has to bring the perspective of smaller employers. I mean, nobody wants to see people discriminated against. You know, we're talking about cases against Disney and against Fox News. They're big corporations. They've got plenty of money to do this. I'm talking about the little guy. I think we should acknowledge that all people who claim discrimination are not equal. There are plenty of situations in smaller businesses where somebody claims discrimination falsely. I certainly, as opposed to, and again, I don't know all the laws on arbitration, forced arbitration versus, I guess, voluntary arbitration. What I would not want to see is just a wild, wild west. Ms. Carlson, you said, we didn't see an explosion of lawsuits. But I tell you, as a small employer, you fear lawsuits. It's the only people who win generally are the lawyers, not the claimant, not the company. So I guess I'd be looking more for a middle ground in terms of, can we make arbitration work? Can we protect those who have? And again, how do you adjudicate whether it's a valid discrimination suit? So again, I'm just bringing the perspective of small employers who are just screwed by a legal system. I mean, it's awful. And again, there are plenty of people who take advantage of it. I mean, not all whistleblowers are created equal. Not all people claiming discrimination. So I'll start with you, Mr. Horton. Just can you comment on that? Can you allay some of my concerns about some of these bills that are being proposed?
Sure, thank you, Senator. That's a very legitimate concern. One of the things I was most heartened at when I looked at how the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act has been playing out in the courts over the last 3.5 years is that there actually does not seem to have been a deluge of lawsuits, and certainly not of frivolous lawsuits. Although it's not in the text of the statute, courts have imposed a common sense limitation in requiring sexual harassment claimant's claim to be plausible, which is the general standard for pleading in federal court. And I know that sounds like a low standard, but in the case of many discrimination claims, it's actually quite a high standard, where the court is inquiring whether or not these facts would actually meet the legal test and entitle the plaintiff to be.
But it starts as a lawsuit, correct? I mean, is there any middle ground first that it goes to arbitration, then get kicked up? I mean, what are the steps here?
Right. So in the case of the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, what usually happens is a plaintiff files a complaint in court, and then the employer moves to compel arbitration. And then there is some sort of court hearing in which either the court decides whether or not the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which I'm just going to call the EFAA, applies or not, and that's what happens. So in these cases, courts are evaluating, are these frivolous claims or not? And there are about 200 accessible decisions interpreting the EFAA. By my knowledge, a very small number of claims have been dismissed as frivolous. So although I completely agree that small businesses are a legitimate concern, there really is absolutely no evidence that giving workers the right to sue in court is producing a flood of claims that are unmeritorious or should not be brought in the first place.
Let me, again, I'm 70 years old, so I'm one of these guys that be concerned about being discriminated against. But again, employers also have a legitimate concern about their own liability. An older worker who's maybe losing something in terms of being able to drive. And how do you address that within this process?
Right, absolutely. It's a delicate and important question. I think what we really need is something that we don't have because of forced arbitration, which is a sense of how these cases actually play out on the merits. I tried to research age discrimination claims in court to prepare for this hearing. It was so hard to find any because they're all sent to arbitration. So I can't tell you whether or not the age discrimination laws should be changed or modified. We just don't know.
Okay, fair enough. Thank you, Mr. Chairman.
Yeah, thank you.